The Slaughterhouse cases of 1873 are widely considered to have slaughtered the Privileges or Immunities Clause of the 14th Amendment. The cases arise out of a law passed by Louisiana that consolidated the meat processing industry in and around New Orleans. Now, the butchers were upset because before they were able to operate independently, now they had to go to this monopolist if they wanted to do business. So they filed a lawsuit arguing, among other things, that this law by Louisiana violated their fundamental economic right to pursue property, to pursue happiness, to pursue their calling as butchers. And they said that right was protected now under the Privileges or Immunities Clause of the 14th Amendment, which had been ratified in 1868. The Supreme Court, in a 5-4 decision looking at the 14th Amendment seriously for the very first time, disagreed with the butchers and said the Privileges or Immunities Clause does not provide such a protection. If you read the dissents by Field and Bradley, you'll see what could have been. And basically what they argue is that the very purpose of the Privileges or Immunities Clause was to incorporate the fundamental rights and apply them to limits on state action. Bradley even went so far as talking about incorporating the Bill of Rights. Unfortunately, these decisions, in my opinion, mucked up the 14th Amendment, and that's why over the following decades you see the emergence of doctrines such as substantive due process and selective incorporation, where the Supreme Court, little by little, incorporated the fundamental rights to apply to limits on state action through the Due Process Clause of the 14th Amendment. Some people today say that there is an emergence in the Privileges or Immunities Clause thanks to a concurrent decision by Clarence Thomas. But it's a fertile area, and some of the greatest legal minds have disagreed as to what these cases mean and what the courts should have done. Yes!